So today we're going to move forward in a significant amount of time past Freeman and Pitts and start with parents involved versus Seattle School District Number One. This case, as you can see, takes place in 2007. The events that led up to this case were largely in the early 2000s. And so some background for this case. So the Seattle School District decided to implement a choice policy for schools, which means that students could, to some extent, choose what schools they went to. Now, some schools in some areas would get overwhelmed with students. A large number of students would go there, and it would be up to the district to determine what students were going to be allowed and what students were not going to be allowed, and what students would get their first choice, and so on. The method by which the Seattle School District decided to sort of break these ties was, well, not the first criteria. The first criteria was something different, but the second criteria was sort of a racially conscious admission system. And what I mean by that is the school district generally had a population that was 40% white and 60% non-white, and they wanted to keep each of their schools around that percent because they thought that the school environment was improved ultimately by having a hello. Okay, someone just bounced in. The school environment was improved by having that percentage. So the tiebreaker that they used was racial identity. So some schools didn't become what they termed racially isolated. The parents involved in the community schools was obviously a group of parents whose students were students in the Seattle School District, and they sued the school district for basically violating the 14th Amendment's Equal Protection Clause. There are a couple issues in this case. They're kind of convoluted, and the reason why I say that is because this is not a straightforward decision. This is what we call a split decision. There are 4 justices that vote one way, there are 4 justices that vote another way, and then there's one justice who joins part of one opinion and part of another opinion. So there isn't an easy majority to follow in this case. So there are 3 questions largely that we have to deal with. The first being, are the decisions in Grutter and Gratz binding on public school students? Grutter and Gratz are cases we're going to do at the end of the section on Thursday. But Grutter and Gratz involved race-conscious admissions plans for higher education, so for college and law school. So the question was, do the precedents from those 2 cases apply to public high school students? Second is diversity, racial diversity, a compelling state interest? And so, as such, can schools regulate on it? And lastly, does a school district that denies a student admission to a particular school on the basis of their racial identity violate the 14th Amendment? So when I say that this this case is a split decision, I truly mean it. There is a majority opinion for certain parts, and that in other parts that stops being the majority opinion. So Chief Justice Roberts writes this decision, the part of the majority. So the way it works is that Kennedy, who at this time was the median justice, the individual who sits in the 5th position on the court, who is thought of as the ideological center of the court, he joins Roberts in 2 parts of the question, but joins the liberals who dissent in another part. So Kennedy is sort of the deal maker. He basically determines the outcome of this case. And with regards to the outcome of the case, this is what the court decides, summarized broadly. So the Grutter and Gratz decisions do not apply to public high school students. First off, they settled that right out of the way, that these decisions that dealt with higher education are not binding on public law school students. They do not provide directive. With regards to whether race has a compelling state interest, that is yes. Race is a compelling state interest. And the reason why race is a compelling state interest is this is the one issue which Kennedy joins the four liberals in dissent. Kennedy very much believes that race can be a compelling interest of the state, or racial diversity can be a compelling interest of the state. But in this particularized case, for Kennedy, a school district that decides against in a public choice program to deny someone on the basis of race is a violation of the Equal Protection Clause. So the majority opinion written by Roberts sort of outlines this idea. First off, they deal with standing, which I'm not going to discuss, but basically, of course, these individuals who are bringing suit have standing. Their children are, students at the school. But they first want to make clear that strict scrutiny applies in this case. Strict scrutiny is an exceedingly high barrier for the government to demonstrate. Strict scrutiny means that the law in question has to be narrowly tailored, and that's really where the Seattle School District loses, and this is one of those parts that Kennedy joins, is that the case in particular, the way in which the Seattle School District and also the Louisville School District, who was also part of this case, the way in which they tailored their race-conscious policy was not narrow. It was overly broad, and you can, based on the decision of this case, you can have race-conscious admissions policies in a public choice sort of school system, but the racial element has to be narrowly tailored to solve for particularized problems. And in this case, it simply wasn't. So Kennedy writes separately, and Kennedy writes separately as a concurrence, and he ultimately argues that diversity is a compelling interest, and it's one that school districts can absolutely pursue. However, it can't be pursued in isolation. That there have to be a number of other factors that the district is also taking into account. Achieving a diverse student population is a good goal, but that diversity also has to be considered with a number of other factors. Justice Thomas also writes a concurrence in this case. Justice Thomas is out there and basically thinks that we should basically legislate just like Justice Harlan's dissent in Plessy, in that the Constitution is by its nature colorblind, and race-conscious anything is a violation of the 14th Amendment. Stevens, in dissent, kind of takes him to task in this regard, and takes, well, the majority in task in this regard, and says very succinctly that there's a pretty good likelihood that the majority in this case would have overturned Brown. And the reason for that is he documents how much the court has changed in his time on the court. You have to understand that Justice Stevens joined the court in 1975. So we're talking that Justice Stevens is deciding a case 22 years after he's been on the court. Or not 22 years, more than 22 years, my bad. So we have a justice who's saying there is not a single justice who was on the court in 1975 that would have voted the way the majority did in this case. And so he basically says that this court is so far removed from Brown that it's running afoul of Brown. And Justice Breyer, who writes the most significant dissenting opinion really documents the de jure and de facto nature of segregation in the United States, and why pursuing sort of race-conscious policies is important, especially at younger ages, of which public high school students are certainly one. One of the things that he points out that the majority sort of lacks is the majority in this case said that, first off, Seattle doesn't have a history of racial segregation within its school system. But there exists, and as Breyer correctly points out, significant historical fact that there were race-conscious segregation programs that went on within Seattle, and more so to the fact, in Louisiana, they were explicitly segregated. And while the district court lifted those segregation orders in the year 2000, Louisville still pursuing these plans is pursuing them because of a history of racially based segregation within their school systems. So this is a sharply divided case. It's a very complicated case in terms of breaking down the majority opinion. The best way to think of what is the majority is whatever Kennedy is part of is the majority opinion, because Kennedy basically dictates where the outcome of this case is. So what we get from this case is that, yes, race can be a compelling interest in terms of public choice programs in public schools. However, not in this case. And you have to make sure your case, the method by which you're doing so is narrowly tailored, which making it the second tiebreaker certainly wasn't in the two cases involving Seattle and Louisiana. Questions?